We are going to go ahead and get started. Hello, everybody. It's good to see you here today for Churches in Court. I've got several cases. I've reviewed 26 different cases that popped up on my case law research filter that I've got through a research system that I've got for different cases across the entire United States in every state in the union. If a church has been in court, I'm going to get a notice of it, and we're going to review that case. At least I'm going to review that case, and then if it is probative, if it's important, if there's something I think that you guys need to know, I am going to make some notes of it, and we're going to talk about it in here. This is an interactive portion, so you are certainly free, if you would like, to join me in discussing this. If you've got a question, certainly interrupt me. You've got your microphone there. Everybody right now is muted, but certainly feel free to unmute yourself, ask a question. If you'd like to get involved and interact face-to-face, you can do so by activating the camera, either on your phone or on your computer, however you're logging into this. And certainly if you're watching on YouTube or Facebook or anywhere else where this video is posted at a later date, certainly feel free to reach out to me with any questions. I'm glad you're watching this. You can reach me at josh@churchgeneralcounsel.com. That's josh@churchgeneralcounsel.com. Let me introduce myself just briefly. My name is Josh Bryant. I'm the managing attorney at churchgeneralcounsel.com. We work to help churches manage risk management and legal compliance issues, but we want to balance those with church growth and ministry needs. We know that attorneys can certainly be quick to push the brakes and stop ministry from happening, and we don't want to do that. We just want to help you do so safely, do so in a manner that complies with the law and manages your risk well. We do that at a low annual rate. Depending on the size of your church, it could be as low as $1,000 a year. It's never more than $2,500 a year for even the largest churches out there, unless you just need an extraordinary amount of work, at which point we'll talk about a custom fee. But on a regular basis, that's it. We're going to help you do tax issues. We'll help you with your policy manual. We'll help you with your bylaws and your articles of incorporation. Any other questions that you might have pop up, we are here to help. We do this as a ministry to churches. This is not a get-rich-quick scheme for us at Church General Counsel. This is a ministry. I'm a former pastor. We continue to offer these services to churches and to pastors at reduced rates off of what normal attorneys would charge, because we do see this as a ministry to the local church. We value the local church because Jesus is coming back for that local church, and we want to protect that local church, which is why we're talking today about churches in court. And so I've got a list of cases here. I've got them written down on some note cards with some notes. I will discuss those cases with you, some important takeaways that you need to know in order to protect your church and hopefully keep your church out of court. And again, if you have any questions, feel free to ask those questions in the interactive portion of the webinar, or certainly feel free to email me, again, josh@churchgeneralcounsel.com, or you can go to churchgeneralcounsel.com, set up a time for a phone call. You can call me. The phone number's on there. Whatever you need, we'll be happy to help in any way we can. All right, let's get started. The first case I want to talk to you about today is Clover Hill Reformed Church versus the City of Hillsborough. This is a case out of the state of New Jersey. And what happened here is that a church had a parsonage. It met the statutory requirements for a tax exemption, except for one in which a tax assessor in Hillsborough, New Jersey, said, you know what, you don't qualify for a tax exemption on this parsonage. And the reason that tax assessor said that you don't qualify is because it was being occupied by an unordained music minister. Now, I have some friends in the discipleship world in churches across the country that would say music ministers certainly do not qualify as pastors, but a court disagreed, all right? And so the government says music ministers are, in fact, clergy. What they said was that duties and not ordination are dispositive in determining whether or not they qualified for this particular tax exemption. And this is important for a very important reason, because there are a lot of exemptions in the law that are based on either the duties of the clergy or the ordination of a person. All right. And a lot of courts right now are refusing to look at ordination because there's really no standardization across denominations, across non-denominational churches, across other affiliations. There's no standardization as to what qualifies as ordination. There are some who would say you could ordain a woman. There are some who say you can't ordain women. There are some who would ordain private school teachers. There are some who would say, no, that's reserved for pastors. And so because there's no standardization, courts have been forced really to kind of start leaning towards this idea that the duties of the employee are what are dispositive in getting a lot of these exemptions. Okay, and that's important. All right. And one of the things that I try to tell churches is that it's important that you try and have a system by which every employee of your church is a minister of some sort. Give them some sort of religious or spiritual duty to perform, even if all they're doing is answering the telephone or cleaning the bathrooms or vacuuming the hallways, whatever that case may be. Give them some sort of ministerial duty. And here's why. If they are considered a minister of some sort by your church, then the ministerial exception or the ecclesiastical abstention doctrine then applies, which basically says the courts are going to take a hands-off approach. They're not going to get involved. It also means that the government, to a certain degree, has to take a hands-off approach, that they can't come out and say, well, we think that you're not clergy, or we think that you don't qualify to be a minister. The government shouldn't be getting involved in that under the First Amendment, and that's where this ministerial abstention doctrine or ecclesiastical abstention doctrine comes from. And so try to write into your job descriptions ministerial responsibilities. Now, what could those be? Those could be, for example, as a custodian or a janitor at the church, that they spend time praying, walking through the church, prayer walking the church. That is a ministerial responsibility or a spiritual responsibility that you could give them. You could make them ushers on Sunday mornings and utilize custodial staff on Sunday morning and give them some sort of ministerial responsibility in the services themselves. Whatever that may be, if you can give them some sort of ministerial or spiritual responsibility to perform, you'd at least have an argument that they are paid clergy and therefore the courts can't get involved. All right. So another thing to look out for here is we need to watch out. We've seen several times throughout the last several months in which tax exemptions for religious organizations and clergy have come under attack. And this is another example of that. We need to watch out for that. So again, if you have any questions on that, feel free to ask those. And if not, we will move on to the next case we've got here. This is Diocese of St. Cloud versus Arrowwood Indemnity Company. This is a case out of Minnesota. It's a real sad case because what's happened is the state of Minnesota passed a law that said it basically repealed the statute of limitations for cases or claims in which a clergyman sexually abused a minor child or even an adult in some cases. All right, and so what that did is that opened up a whole lot of claims that could be filed against a church that were long since past the statute of limitations. In fact, the cases that were being argued about between this insurance company and this diocese, they actually took place in the late 60s and early 70s. So lots of problems involved in that law, number one. Number two, just lots of problems that could come up in trying to defend that kind of a lawsuit. But even involved in that, there was an insurance company. The diocese contracted with an insurance company to go out and pay claims that were made for cases like this. And then the insurance company and the diocese got crosswise, and it was decided that the diocese was going to sue this insurance company. So this was a dispute over who would pay claims for this clerical abuse. All right. And so the court made several determinations. There were 8 or 9 different counts that were pled. The court basically here was responding to a motion to dismiss some of those claims or a motion for summary judgment saying that you're not entitled to go to court on these issues. And the court agreed with the insurance company. They were, number one, there was a claim of what's called promissory estoppel. And promissory estoppel basically means that you promised me something and then I detrimentally relied on that and then you broke your promise. It's a quasi-contract. Even that's a bad word because quasi-contract is a term of art, but it's like a contract. You promised me something, I relied on that promise, and now I'm going to sue you because you broke that promise. The court said, no, that's not going to fly. You're not going to get to go to court on that one because you have not pled in your pleadings. You've not said that there was any specific, very clear promise as to what the insurance company promised they were going to do in terms of paying these claims. And there's certainly been no allegation that you detrimentally relied on that. You were going to have to pay those claims, whether you had an insurance company do it or not. So the court dismissed that claim. They also dismissed a bad faith claim. In many jurisdictions, if an insurance company does not pay claims in good faith on their contract, then that insurance company could be sued for what's called bad faith or breach of a fiduciary duty, depending on what jurisdiction you're in. And what that basically means is that if the insurance company does not act in good faith, then you can sue them and not only recover the damages for the claims that they were supposed to claim, but you can actually recover double or triple damages because insurance companies are heavily regulated by state governments especially, and because insurance companies are expected to pay claims in good faith. And if you don't do that, there should be some punishment involved, is basically what the law is saying here. The court said, sorry, you didn't point to any clear policy language that said these were the specific claims that they were going to pay. It was very broad and amorphous, and so the court was not going to allow them to pursue a bad faith claim. Fraud is another claim that they had tried to pursue against the insurance company, and in this particular case, fraud had to be alleged very specifically. You had to talk about the dates promises were made, the dates statements were made, the date the fraud occurred, and all those other things. And the court said, I'm sorry, you didn't plead that right. And further, you didn't detrimentally rely on anything that you alleged was fraudulent activity. And finally, there was one called tortious interference of a contract, which the court also dismissed, basically saying this was a very complicated set of transactions, but in the course of all this, an insurance company acquired several other insurance companies that were kind of self-dealing and kind of doing some crosswise things. And ultimately the court said, you can't prove that. There's not enough information here to act on. And so the court dismissed that claim. Here's what you need to take away from this, though. There's a lot more litigation in this particular case to come because, again, there were 8 or 9 counts, and the court only dismissed 4 of them. So there's a lot more litigation to come. But here's what you need to take away. First of all, you need to have an attorney review your insurance contracts, okay? And that attorney needs to be able to tell you exactly what is paid and what circumstances, and this is probably more important, what circumstances are there in which a claim could not be paid. And this is especially important on special insurance that you might require. So, for example, one of the big topics right now is church security and getting sufficient insurance to cover your church in the event that you have an emergency response team that acts in a manner that uses too much force or hurts somebody or something to that effect. That is a special insurance policy. Sexual incident insurance is another type of insurance that you can get that covers sexual acts of pastors and clergy. You need to have an attorney review that particular policy and talk to you about what conditions or what things might happen that would cause that insurance company not to pay that claim. There's other ones. Employment liability insurance is one of those types of insurance where you need to have an attorney tell you what circumstances might exist in which the insurance company wouldn't pay a claim under that insurance. So whatever the case may be, have your attorneys represent you, have them advise you and give you good counsel on what might be paid, what might not be paid, so that then you can develop policies and practices and procedures that will fill those gaps in what insurance isn't going to pay, okay? You've got to be very intentional. You need to know exactly where those gaps are in your insurance coverage so that you can take appropriate steps in covering those gaps. So have them look at that, but more importantly, make sure that your sexual conduct policies are in order, okay? This is a case that never, ever, ever should have happened. It never should have gotten to court simply because we should not see these incidents. We should not see problems with clergy sexual misconduct, especially on minor children. So make sure you've got your child protection policies in place. Make sure that they're going to do what they need to do. Make sure that you're protected on that front. And we certainly, that's one of the top priorities that we have at Church General Council, is making sure those policies are in place. All right, next case. This is an employment case, Jajua versus Diakon Lutheran Social Ministries. This is a ministry in the state of Pennsylvania that owned a healthcare facility. And there was some really egregious conduct going on from an employment standpoint. For example, the plaintiff here is African in descent. moved here, I mean, as an African immigrant, moved to the United States, had a very thick kind of French accent, it sounds like, from reading the case. And basically, there was a supervisor here that said, you know, your African food that you're heating up in the microwave, it smells bad. The supervisor would say, you know, you Africans are stealing our jobs, and you're stealing our hours, and you're stealing our money. When management got wind of this and the plaintiff complained to the management, they said, well, maybe this supervisor is just joking, and then didn't do anything to step in and stop that conduct. They refused to give this employee breaks, and they would give the Caucasian employees breaks, but not her. They wouldn't promote her. They kept promoting some Caucasian nurses to a day shift, and wouldn't promote her despite having a great interview and great performance reviews after she was fired. Probably inappropriately, the case isn't over yet, but probably inappropriately fired after she was fired. She was replaced by a Caucasian person, and all of that stuff is going to be able to come into court. There was one claim that the court dismissed, and it was because there was enough evidence to suggest that that particular employment action was at least justified. It was a paid suspension, but there were a whole lot of other employment actions. There were write-ups, there were disciplinary procedures, the ultimate, the firing at the end of her employment there, the comments, the hostile work environment. All of those claims are going to be heard. So you've got to make sure you have good anti-discrimination policies in place, and then you've got to follow those policies. You know, you've got to train your people, train your employees on what it means to have a hostile work environment and what not to do, because that's going to create liability for your church or your ministry. And certainly, you've got to deal with discrimination and harassment claims as they come up. And that's probably the most egregious thing that's going to get this particular ministry in trouble, is that there was a claim of discrimination and they did nothing about it. You have got to investigate those reports. And certainly at Church General Counsel, we can help you do that. We can help you devise kind of an investigative strategy and how you investigate those, what documents you need. And listen, that's our whole goal, is our desire is to help keep you out of court. And the more documentation you have, the better procedure you follow, the more investigating you do when these claims come up, the better chance you have of not going to court on an employment discrimination case. And so you've got to be able to investigate this. And if you don't want to do that internally, that makes a lot of sense. We at Church General Counsel can help you investigate those things, and we can be your investigator. So take some time when you get those complaints, especially of discrimination, and even more so in terms of harassment. Right now, that's huge. You've got Bill Hybels, who is just in the news on sexual harassment claims, and fortunately, Willow Creek did well in investigating that. It seems like there's some differences of opinion on that, but the news articles that I've read suggested that Willow Creek did a good job of investigating all of those claims and did so independently. They had a lawyer come in and conduct an independent investigation. And so make sure you're following up on those claims. That's very important. All right, let's move on to the next case that was decided in the month of March. This is White Knight of Flashbrush, sorry, LLC. This is against a Reformed Protestant Dutch church there in that municipality. And basically what happened here, and we're going to see a lot more of this coming up with the increase in multi-site and church plants. But basically what happened here is that a church signed a lease-to-own agreement with a company on a church facility, on a property. The church then contracted, and it was hard to tell from reading this case whether they did so before initiating that option to purchase or exercising that option to purchase, or after, but they ended up contracting to sell this particular piece of property. Well, the landlord plaintiff sued the church for specific performance, and then sued the buyers of this property that had contracted, sued them for what's called tortious interference of a contract. And so let's talk about specific performance real quick. Specific performance is what we call an equitable remedy. It basically says, listen, I can't recover monetary damages from you because that's not going to fix the problem. The only solution to this problem is that you do what you said you were going to do in this contract. And so it's an injunctive type relief where a plaintiff goes to a court and says, Judge, I want an order that requires the defendant in this case to perform this contract. All right. And so ultimately, those claims were dismissed for various technicalities that I won't go into because it dealt more with civil procedure than it did with anything that's dispositive to court, to churches. But the court dismissed those claims. But here's what we need to take away from it. All right. First of all, this is going to, again, occur more and more as multi-site and church planning scenarios take off. Okay. Because we're always looking for ways to save money. And we're going to talk about that more in another case here in a minute. So we're looking at ways we can save money. We want to plant more churches. We want to engage in more multi-site, but the more facilities we've got, and the more time we're trying to, start churches from scratch on low resources, we're going to try and save money. And these lease-to-own options are a decent means of doing so as long as they're done properly. And in this case, it doesn't sound like it was done properly. You need to have an attorney review any type of lease-to-own agreement. These things are fraught with problems. Okay, any kind of lease-to-own agreement, there are all sorts of problems in it. There are tax implications in doing installment sales like that, and so it's got to be done properly. You need to have an attorney review that document, and then you need to have an attorney help you execute what you're supposed to do under that document. There are certain tax filings that need to be done. Your accountant can certainly help you with those. Your attorney can do so as well. There are going to be deeds and things like that need to be properly recorded. There's a title company that's going to need to be get involved. A lot of people think they can go into these agreements just like they would a normal lease, but that is just not the case, because if you exercise that option to purchase and you haven't followed proper steps, then there are going to be huge tax ramifications. You may not, the landlord turned seller may not even have good title to the property, and so you've got to make sure that you're dotting your I's and crossing your T's. This is another case that really should not have ever become a problem, and so there should have been an attorney involved much sooner in that particular case. All right, let's actually go on to another case that talks about that. I'm going to skip order here. This is Unity Non-Denominational Church versus Vincennes Corporation. This is a case out of Indiana. And what happened here is it seems like it was probably a church startup, but I'm not 100% sure. The church went and acquired property by what's called a tax deed. So a property owner got behind on their taxes. There are some jurisdictions which will allow you to go pay those taxes, but then get a tax deed. And then there are notification requirements about notifying the property owner that you have this tax deed, and if certain things aren't done within the right time frame, then you now own that property. And it's kind of like buying a property in foreclosure, except in this case it's in tax foreclosure and not a bank foreclosure. So there are deals to be had out there on property. Again, you can save money by doing this, but by doing that particular thing, there is also a greater amount of risk. And what happened here is that the county clerk that was responsible for record keeping made a mistake and gave the purchaser of this tax deed the wrong address to send notification to. Well, and the purchaser of that tax deed didn't do his own independent research to make sure that he was sending notification to the right place. He sent notification to the wrong place. Nobody answered that notice saying we're fixing to take ownership of this property. Well, after they had already started the process of getting this property and probably getting ready to build on it and things like that, what happened was the owner of the property got wind of what was going on and said, hey, you didn't send me notification of what was going on. And the court undid everything, made them go back and file new notices. Of course, by then the property owner went and repaid all the taxes, and the property owner ended up getting possession of that property back. So you've got to be careful getting property that's in foreclosure or any kind of tax deed or out of a bankruptcy court or anything like that. It does save money, but there can be increased risks, and you need to have an attorney help you manage that risk. All right, here's another property case. I promise not every case that we're talking about is property, but there's a lot of churches right now in court for property issues. This is a case called Jesus Christ is the Answer Ministries versus Baltimore County, obviously out of the state of Maryland. And what happened here is a plaintiff bought a piece of residential property and renovated it. All right. She did so on the understanding and on the statement of her realtor that a church could meet in that particular property. She spent thousands and thousands and thousands of dollars to get this done. It was on 1.2 acres, 2,900 square feet, and so there's enough for a small church to meet there. The problem is that she did not review, at least in the court's eyes. I think this is a little bit of a specious case, and I think it's ripe for appeal, and there could be an appeal that overturned this particular case. But this particular appellate court said, look, you should have gone and looked at the zoning regulations yourself. And because she didn't do that and she just relied on the statements of her realtor, that created problems for her. Now, the realtor could have some liability here as well. But ultimately what's happened now is the church can't meet. The church has been shut down. They can't meet in this particular facility. And so the claim that this particular church made in court was that it was a violation of the Religious Land Use and Institutionalized Persons Act. And what that act is, it is a kind of a restatement of the Religious Freedom Restoration Act after the Supreme Court did some things that kind of gutted the Religious Freedom Restoration Act. I think this happened back in the 90s. And what that requires is that before certain zoning regulations can be passed, or at least before they can be enforced against a church, the government has to do so in a manner that does not create a substantial burden for that particular ministry. Okay, and I know that's kind of a complicated way to say it, but basically, if you're going to claim relief under the Religious Land Use and Institutionalized Persons Act, you have to show that a particular zoning regulation or the enforcement or the application of that zoning regulation puts a substantial burden on your First Amendment rights as a church. The court here said, no, there was not a substantial burden because you didn't review those zoning regulations by yourself. Had she done so, she would have known, or at least she should have known, that there was going to be a problem in this particular instance with zoning issues. Now, I don't really like that particular argument because the zoning regulations are exceptionally complicated. It was difficult for me as an attorney to read those regulations and know exactly what was required. And so for her to go and review those herself, I wouldn't expect any layperson, no pun intended there, but anybody outside of the legal world, I wouldn't expect them to necessarily be able to understand exactly what was required. Certainly, even an architect might be somebody that you need to talk to, or an engineer, or somebody else who does some of these civil engineering type things, and builders, contractors, people like that may need to look at some of these regulations in order to be able to tell you exactly what's required for your church's zoning requirements. So again, I don't like that argument, but that's what the court ruled. Secondly, the court said that there was no religious liberty claim here because of how the court was establishing what was going on. And so, again, gets a little bit complicated, but basically what they said was that the way in which this particular statute was applied, or this ordinance was applied, it was applied neutrally. It didn't matter if you're a religious organization or not. Nobody could have occupied the property in the means that you were wanting to do so. Certainly something that needs to be paid attention to there is that if you're going to claim religious liberty, you've got to put yourself in, first of all, if you're going to say that you've been discriminated against because of your religious liberty, you've got to make sure that other churches are being treated similarly. And in this case, they didn't allege that. Which kind of goes to the third point as well. They said there was no discrimination claim. They couldn't say that they were being discriminated against. And in this case, I certainly disagree with the court's ruling on this, but it is what the court ruled. Mainly, my disagreement is found in the fact that the way that the statute, or the ordinance in this case, read, it allowed for residents around the particular area to form what's called a people's council. And then that council could go into the planning commission's meetings and make objections and present their own case as to whether or not certain zoning variances should be granted, or whether a property should be rezoned, so forth and so on. This People's Council that was sanctioned by the government and put together under that statute or ordinance said, look, we don't want them in here because, again, this is another organization that was of African descent. They were from Kenya, in fact, and they had associations both in Kenya and in the Seychelles Islands, or the Seychelles Islands, depending on how you want to pronounce it. So they would come in and say, listen, we don't want these guys dancing around like they're still from Africa. We're not going to have that in our neighborhood. We're not going to have these chants and these loud musics and the bongos and yada, 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 and all this stuff. And so they were very certainly making some discriminatory comments. It's unclear whether the decision was based on that, but if an organization sanctioned by the government, formed under an ordinance or a statute passed by a legislative body of the government, comes in and starts making those types of discriminatory comments, I think that you've got to take a little bit closer look at that. All right, 2 more cases and then we're going to be done. I appreciate you guys sticking this out. This one is actually a little bit tongue-in-cheek. This is Sohn versus Oriental Mission Church. This church had the forethought and the foresight to have an attorney on retainer. However, they did not have the foresight to pay that attorney, and the attorney sued them and got a judgment. So the moral of that story is pay your lawyer. All right. Joke over. Next case. This is a case out of Montana. It's our last case. It's called McLean versus McLean. And this kind of goes to some of the marketing I did on this particular webcast about whether an administrator or a senior pastor or somebody who's on staff at a church can go to jail for church business. And the answer to that question is yes. Okay, you can go to jail for how you do church business. Specifically, in this case, it was based on withholding taxes. All right. 27 United States Code section 7202 is a criminal statute that says if you are the person responsible for tax withholdings, for income tax withholdings, Social Security, Medicare as well, or your state income taxes probably, if you're the person responsible for that and you do not properly withhold, or you knowingly don't withhold, or you do withhold and do not pay that over to the federal government, you can be fined no more than $10,000 and spend no more than 5 years in jail, or both. And in this case, that happened. In addition to that, there can be what's called a civil penalty. And so it's a criminal penalty and a civil penalty. The civil penalty is found in 26 United States Code section 6672, and it will allow the government to pursue that civil penalty up to the amount that should have been paid in income taxes, Medicare, and Social Security taxes. So administrators and senior pastors, you need to pay attention to this because you can be personally liable. If you don't do it properly, if the government or a prosecutor or United States attorney somewhere decides that you acted in such a fashion that you knew what you were doing violated the law, there can be criminal liability for that. There can be criminal liability for other things as well. The chief one that comes to mind off the top of my head is your mandated reporter laws. If you are a mandated reporter, which you are, as basically anybody on church staff, I'm going to go ahead and tell you, err on the side of caution, you're a mandated reporter. If you come across information that a child has been abused and you do not report that, that is a criminal offense and you can be imprisoned and fined for that. All right. Now, the next thing that's a key takeaway from this particular case is do not do this stuff on your own. Okay. There were contracts involved. There were property conveyances involved. This was a big, huge mess. And it existed because a church tried to, on their own, and actually this was a ministry. This wasn't a church, but a ministry tried to, on their own, without the benefit of an attorney, convey property, sign some contracts, assign certain duties and responsibilities one way or the other. And it became a huge mess. They did it on their own. And then to make matters worse, they went to court on their own without an attorney. And they started filing their own pleadings and their own motions. And the court, you can tell by how the court read or wrote this particular case, they were getting a little frustrated with it and basically dismissed the entire defendant's arguments on this particular issue. And so don't go to court alone, ever, ever, ever. Don't try to sign a contract without having an attorney review it. That's very, very dangerous. You got to make sure you know what your responsibilities are under that contract and what your rights are as well. And certainly don't try to convey real property, land, buildings, anything like that, even vehicles. Vehicles are a little bit easier, but certainly not real property without the benefit of an attorney to take a look at that and go through title companies, get your title insurance and all of that good stuff. So that concludes my review of cases of churches in court in the month of March. I will stick around here for just a little while to see if there are any questions. I'm going to go ahead and